Good morning to you all. And to Dean Raymond, thank you so much. It's my privilege and my honor to come back to this place where I don't think I've been back here more than 3 times in the 45 years that I've been gone, but it's wonderful to be back and to reconnect and to see all of the changes that have been made here. I'm deeply honored and privileged to have been asked to serve as the keynote speaker for this occasion to celebrate all of you who have come here to Madison to begin the first steps on your journey to become lawyers, members of a profession that is at once challenging and fulfilling. I'm especially pleased to celebrate the memory of Professor James Jones, whose name is given a place of honor in the program in which you are participating. Professor Jones was the Nathan Feinsinger Professor of Labor Law. He was the first African-American professor at the University of Wisconsin Law School. He was the grandson of a slave, and he was a big supporter of the law school's legal education opportunity program. When he came here, I understand that he said to somebody, "Where are the black people?" Because they were few and far in between. I arrived here the year before he did. I arrived in the fall of 1968. He came in 1969. He was a friend and a mentor, although it was not love at first sight. We were both kindred spirits because he was the only African American on the faculty, and I was one of only 4 African American students who started out in the class of 1971. But I think by the time he arrived, there were only 2 of us left, a male and a female. And my time in Madison was, I guess I could say, interesting. I had no idea, having grown up in Mississippi where the temperature never gets below 30 or almost never gets below 30. My first winter here, I took it upon myself to walk a couple of miles from one friend's house to another friend's house, and I was wearing a pair of fashion boots with no hose and a coat that I had brought from Mississippi. And when I got to where I was going, I thought I was frostbitten because I had no feeling in my legs. But that was my introduction to Wisconsin winters, and it was not a pleasant introduction. Needless to say, I was thinking about right then, how do I get out of here? In the time I've been given, I want to share with you my story of how I came from a little Mississippi Delta town where Jim Crow reigned supreme to be the first African American woman to serve on the Massachusetts Supreme Judicial Court in the 322-year history of the court. I want to tell you this story not as an act of self-congratulations, but to inspire you, because if I can do it, you can do it. When I began my journey almost 50 years ago, role models were few and far between. But for you, the role models are far and wide. My story is just one of the many that may offer you a view into the way forward with your career in the legal profession. Some of what I have to tell you will be unfamiliar unless you're a student of history. I went to college in 1964 as a 16-year-old freshman from a family of 10 children, none of whom had ever gone to college before, with 2 parents, neither of whom had graduated from high school, and one parent who could not read and write. I had no history of activism, despite everything that was happening around me. As you may remember, by that time, black people in Mississippi and elsewhere had awakened from the long slumber that followed Reconstruction. SNCC workers had descended on Mississippi for the Freedom Summer in 1964. James Chaney, Andrew Goodman, and Michael Schwerner, three civil rights workers, had gone missing, and their bodies were found buried in an earthen dam 44 days later. They had been kidnapped and murdered by the Ku Klux Klan near Philadelphia, Mississippi, just months before I left the comfort of home to go to college. And the year before that, in 1963, Medgar Evers, the local head of the NAACP, was shot and killed in cold blood as he returned to his home in Jackson from a meeting with lawyers for the NAACP. Seeing all of this, I allowed the spirit of rebellion to inhabit my spirit and to guide my path into a life of struggle for justice. It was impossible for me, living the life that I lived in the Mississippi Delta, in a town intent on keeping alive the values of the Confederacy, not to appreciate fully the injustice flourishing all around me. As a student at my college, where civil rights icons of all ages and stripes came together, I learned that it was not cause for despair. Instead, it became the defining purpose for my life. I came to see the law as a partner in the struggle for racial and social justice in this country, and I was committed to follow that path. So I came to my calling as a lawyer early on, in spite of the fact that at that time, I believe there were only 4 lawyers of color licensed to practice in the state of Mississippi, and I knew only 2 of their names. So when a white kid from Wisconsin named Jim Miles, who was then a second-year student at this law school, came to my college in 1967 looking for black students who might want to apply to the University of Wisconsin, I thought, okay, let me hear what you have to say. I had never given Wisconsin a thought, but circumstances made me open to the possibility. I had been rejected for admission by Ole Miss, the University of Mississippi, and a host of other Southern law schools, so it seemed like the thing to do to listen to what Jim Miles had to say. I came to Madison, sight unseen, no visit for me, no month like what you have had, in the late summer of 1968, to begin what turned out to be an incredible journey in the law. The story of how I came to be the first African American woman on my court is really not about me, but I have to tell it to you anyway. And my story cannot be explained by a resume that highlights the victories and ignores the defeats. It would be the height of arrogance to presume to take credit for where I am today. My journey from Mississippi, a place where the spirit-crushing regime of racial oppression claimed so many dreams, so many possibilities, and indeed so many lives, to the place and time where race is said to be neither a benefit nor a burden, did not happen because I willed it to be so. I know in my heart that I have been privileged to do the work I have done as a lawyer and as a judge over the past 45 plus years because of the sacrifice of countless men and women whose names have been lost to history. And so whenever I get the chance, I pay special tribute to people like Fannie Lou Hamer, my personal hero, a woman of immense courage and strength who struggled to the death to see a new day dawn for black people and for people of color all over this country. I can never forget how she stood against the powerful people and institutions arrayed against her at the 1964 Democratic Convention when she spoke out against the rejection of the Mississippi Freedom Democratic Party that had anchored itself at the college that I went to. She stood boldly in front of the microphones with her Mississippi accent, not understanding anything about subject and verb agreement, but we were all inspired by her courage. And I have summoned her memory many times when I was tempted to surrender principle to power. At that time in our history, she and others gave it all and more, even though they must have known that there was likely nothing in it for them personally, and that the fruits of their labor would be harvested, if at all, by the generations to come. Everything that I am and everything that I have done in my life in the law has been made possible by the sacrifice of others. I claim no personal victory in the honors that have been bestowed upon me. To paraphrase prophetic words spoken at another time in another place, I have survived and thrived on this journey because I have been blessed to live in houses I did not build, drink from wells that I did not hew, and eat from harvests that I did not plant. If you went to Sunday school when you were little, you may recognize those words. Indeed, just as I was, you are all beneficiaries of the extraordinary efforts of people you will never even meet. This is an undeniable truth that I hope you will accept if you don't already, and carry it with you as you plot your career, your course to a career in the law. You are here not only because of your promise to do well and to be good, but because we expect that of you. Now, I just want to talk for a few minutes about lessons from lawyering and judging. When I went to law school in 1968, I was firmly convinced that the law would be the servant of change that we yearned and fought for, that the law would be the best weapon in our fight to solve what W.E.B. Du Bois described as the problem of the 20th century, now the 21st century, with no end in sight. We were inspired by the promise of Brown versus Board of Education, which was decided before any of you were born or even thought of by your parents. Everybody knows the story of how Brown rejected the old regime of Plessy versus Ferguson, which had been decided in 1896. Plessy sanctioned state racism and told us that it was possible to be separate and equal. It was an important moment in our history. Brown opened the doors to social change and led to the dismantling of Jim Crow laws that inflicted pain and humiliation on black people all across the South and elsewhere. It emboldened a generation of young warriors for racial justice, people like John Lewis, Bob Moses, and others who carried the banner for SNCC. And it validated the prescience of others who never accepted Plessy as the final word on what our place should be. The promise of Brown brought many of us into the profession, eager to wage legal warfare and shaping its legacy. And I watched from the sidelines as the legal giants of my day, Thurgood Marshall, used every weapon in their arsenal to coax progress from the indifference and intransigence that followed the decades after Brown. The legal attacks on the racial status quo that followed Brown revealed a Constitution that, despite the genesis and purpose of the post-war Civil War amendments, is, as you will learn, a fickle, unreliable, and reluctant partner in the struggle for racial justice and equality in America. The lawyers of my generation followed in the footsteps of the legal giants like Thurgood Marshall. We won some battles, but we lost many more. There are so many injustices that persist in our country, injustices that have escaped our best efforts to conquer them. I could remind you of a few of them, but I will only mention one here. The Voting Rights Act. Recently, the Supreme Court declared unconstitutional a key portion of the Voting Rights Act that was reauthorized by Congress in 2006 for another 25 years after gathering a compelling mound of data showing continued discrimination in voting. In a decision that portends disaster for minority voting rights in this country, the Supreme Court struck down a critical provision of the Voting Rights Act, claiming that Congress overstepped its bounds by requiring only Southern states to submit proposed changes in voting laws to preclearance. But the court overlooked the massive findings of Congress to justify the extension of the Voting Rights Act. So we now have a Voting Rights Act that can, for the most part, be saved only by Congress revisiting the issues to meet the court's objection. What is left is a law that prohibits individual discrimination and places the burden on that individual to prove discrimination, when before the states were required to prove that voting changes were not discriminatory. And you may recall, if you watched the news reports carefully, within hours of the Supreme Court's decision, the state of Alabama swung into action, closing polling places in mostly minority communities. Now, I tell you this not to discourage you, but to impress upon you that there is so much left to do. These issues are no less urgent than when I left here almost 50 years ago to join the struggle that beckoned to me. What we all started has not yet been finished. We need committed young people of all races in the profession who want to build a new world free of the chains that bind us to racial discrimination, free of the chains that bind us to the notion that Black lives don't and shouldn't matter. We are in desperate need of fresh troops. You are those fresh troops who must take your place in the army of warriors. My advice to you, prepare yourself as you are doing now. Get engaged. Remember your history. You have to be engaged and stay the course. The lawyers of my generation have fought the good fight. Next year, because I'm aged out, I will have to retire from the Massachusetts Supreme Judicial Court. We cannot sit after age 70. I'm totally fine with that. I am ready to go. But it's just emblematic of what is happening. The folks who have been on the front lines all these years, we're tired, we're old, we're broken down, and we can't wait for you to get started. Thank you for listening.